Sure. I'm Randy Barnett. I'm the Carmack Waterhouse Professor of Legal Theory at the Georgetown University Law Center, where I also direct the Georgetown Center for the Constitution. The Supreme Court did not do its job. I think if you study the history of the Supreme Court, it's mostly a history of the Supreme Court not doing its job. That's why when I teach my casebook, which is very Supreme Court focused, is certainly not, it does not always show the Supreme Court in a good light. It's one case after another in which the Supreme Court abrogates its responsibilities, and typically what it's doing is it's failing to say no to the legislature, to Congress. It's failing to say no to the executive branch. But it's primarily failing to say no to Congress, partly because what Congress is doing is popular, and the Supreme Court tends not to deviate too far from what popular opinion is at any given time. And so when, for example, the North withdrew from the South and gave up on Reconstruction, and essentially let the Southerners do what they wanted with the freemen that were there after the Civil War, the Supreme Court didn't get in the way. In fact, they pulled back. You know, they pulled back their doctrines just the way the Northern armies got pulled back. I don't think this was the Supreme Court's finest hour, but it is typical of what the Supreme Court has done in the crunch. And so this is another example, was where crunch time came. You can't really count on the court to do the right thing, or by following the Constitution where it looks like it might create a political problem for the court. I don't know that I have a good explanation of what accounts for the failure. I do think the court tends to want to preserve what it thinks of as its legitimacy by not straying too far from what popular opinion might be on a given topic. I think individual justices are influenced by the peer groups whose opinion and respect that they want to garner, and I think we're all like that. I'm certainly like that. I think it's a human trait. To want to get the respect of the people whose opinion you respect, and as a result, one sometimes shapes one's behavior accordingly. It should look to the Constitution, and it should question any of its own doctrines that seem to be trying to get around the Constitution. I mean, we have. The name of my book is called Restoring the Lost Constitution, and I'm not interested in restoring a lost constitutional law from some bygone era. Any bygone era you point me to, I can point you to all the injustices that were taking place in that particular era. It's talking about restoring the clauses of the Constitution that are now gone. And ask any litigator, any constitutional litigator who's watching this video, ask them whether they can go into court and litigate the Ninth Amendment. Can they litigate the Privileges and Immunities Clause? Can they litigate the Origination Clause that says revenue bills must originate in the House? Can they litigate the Contracts Clause in any but a small number of areas? Until recently, could they litigate the Second Amendment? No. Could they litigate the Commerce Clause and Necessary Proper Clause? Well, yeah, but only if Congress does something way, way out. As a result of the Rehnquist Court, but prior to 1995, not that either. And so one clause, and I haven't even got to most of them, one clause after another of the Constitution has been interpreted by the Supreme Court out of existence. That's the reason why I became a contracts professor, because when I took constitutional law from Larry Tribe, who was a brilliant teacher, basically when I read what the Supreme Court had done to all what I considered to be the good parts of the Constitution, I decided if the Supreme Court isn't going to take the Constitution seriously, then why should I? And when I became a law professor, I became a contracts professor, where contracts are taken more seriously, and as is the doctrine taken more seriously. So for that reason, it's only been since I became a law professor later on that I was able to decide that after I had tenure, it would be okay for me to say that the parts of the Constitution that lawyers can't litigate ought to be brought back and made the law of the land. So I think if the Supreme Court actually followed all the Constitution, it would be a lot better off, and we would be a lot better off. the Constitution is designed to get in the way of what legislatures do. It's designed to facilitate what they do because it's seeking to empower a government, but it's also seeking to restrict that government, and those restrictions can get in the way of what popular majorities want to do and even what special interest minorities want to do, and when they have the clout in the legislative process. So the Constitution is designed to get in the way, but when something is popular and when something gets enacted, the Supreme Court, based on its culture and where the justices tend to come from, the Supreme Court is reticent to actually stand in the way of what most people want to see done. Most people are reticent to stand in the way of what most people want to see done. I don't like expressing, strong minority views. I like to go along. I like to express views that I think my audience is going to agree with. And because I think that's human nature, what they've tended to do over time is take the parts of the Constitution that have gotten in the way, and they've interpreted them out of existence. And then they rely on their precedent, which have done that, from then on in, so that those parts of the Constitution have been lost and they are no longer operative. Now, my colleagues on the left think that's a good idea because many of them actually don't like the original Constitution, and that's the reason why they're down on the original Constitution and start, using ad hominems. I guess you can't do an ad hominem against the text, but they do ad hominems against the people who wrote it. That's when we hear so much about how it was written by slaveholders and it was written by white males, and this is a way of delegitimating the text of the Constitution. That's why they're saying these things, because they don't like what they say, because what it says gets in the way of what they want to see done. It's not true that the Constitution is consistent with every public policy. It's not true. And if it were true, you wouldn't have to eliminate the clauses that got in the way. And I think every lawyer out there listening to me knows that they can't litigate certain clauses because they're gone. How do you get to be a Supreme Court justice? I mean, who gets to be a Supreme Court justice? You have to be someone who's nominated by the President of the United States and confirmed by an elected Senate. This tends to limit appointments to people who are what we might call mainstream folks. They're people who travel in the circles that all the other people would travel in who would get to that path. They tend to think conventionally, which is kind of how the system is set up. If I'm going to say I like the Constitution, I have to, or I think we ought to follow the Constitution. I think we ought to follow the Constitution that says the President gets to nominate and the Senate gets to confirm. That has certain consequences. Not all of them are good. You end up having a relatively mainstream Supreme Court. Even though there are divides, there's no question there's a left and a right side of the court, that's a relatively mainstream Supreme Court that basically all share in common the view that they don't want to get in the way too much of what the public at any given time thinks is necessary and proper. I think this is a very understandable view to have. It's just the problem is that over a 200-year period of time, when some issue comes before the court and then the court buckles with respect to that issue and modifies its doctrine so as to get around the text of the Constitution, with our system of precedent, that tends to stick, and it's difficult to go back and revive the original text of the Constitution so that it does the work it was designed to do. The Constitution is sort of an integrated machine, or put it this way, the Constitution is like an airplane that has redundant systems built into it in order to prevent a crash. And what happens, you eliminate one engine on a 4-engine jet, you can still fly pretty well. You eliminate 2 engines, well, now not so now, but you eliminate 3 engines, you can still fly, but you're not flying in the same way you did before. You're not flying quite as well. By eliminating one part of this integrated document after another, we are left with stuff that has kept us one of the freest countries in the world. But we are doing it on redundant backup systems. The Bill of Rights, for example, was a backup system. It wasn't the original system. It wasn't there for 2 years. It only got added as a redundant safety mechanism because some people did not want to get on the boat, to change my metaphor from airplanes to boats. They did not want to get on the boat without lifeboats on the boat. And so they said, fine. James Madison said, we need to get these people on. We only have 11 states in. We want to get the other 2 in, and we're going to deliver on our promise and give them amendments, and we're going to give them these rights, and then hopefully they'll trust us and they'll get on the boat. These were not considered the primary constraints on government. They were the backup safety mechanisms, the lifeboats that were put on the boat in case the rest of the structure of the boat would fail. And we've been operating on these backup systems for quite a long time. They've been relatively good, better than not having them at all, but not as good as having the entire structure of the ship operating as designed. I'm saying the Bill of Rights did not exist. First of all, it wasn't called the Bill of Rights for quite a number of years. It was the amendments to the Constitution. And it did not exist for 2 years. For 2 years, we had a Constitution, the structure of which did not include an express Bill of Rights. But the people were very skeptical of this. They said, we don't trust this boat. We don't trust the structure that you've designed. And we need lifeboats. And the Bill of Rights are a backup lifeboat situation. But I'll tell you, if you're on an ocean and your boat goes down and you're in the lifeboats, you're not in your first best situation. It would be better to be on the ship than it is to be on the lifeboats. And the Bill of Rights is our backup, redundant safety mechanism in order to protect us when the structure is not working. That's what they're there for. They're there to protect us when the structure doesn't work as it's supposed to. And because various elements of the structure have been eliminated one after the other, we're left to rely on a Bill of Rights. The problem with the Bill of Rights, getting back to the Ninth Amendment, is it's radically incomplete. It's 8 amendments, and it only covered a certain number of things, the things that were of most concern at the time. It doesn't protect all the liberties of the people, and the Ninth Amendment is there to remind people that it doesn't that these are not all the liberties that the people have. So the Bill of Rights, if you're going to limit, and as you mentioned footnote 4 earlier, footnote 4 is supposed to be limiting the judicial power to the express prohibitions of the Constitution. It's not what the court has ever actually done, but that's the theory of it. Well, the express prohibitions are few and far between. Because there have been sort of general, what you might call a savings clause for the rest of the liberties, which are the Ninth Amendment with respect to the federal government and the Privileges or Immunities Clause with respect to the states. But both of those clauses have been rendered inoperative by the Supreme Court with the consent of both the left and the right of the political spectrum. Elements of the left and elements of the right side of the court are in agreement that they don't want to revive the Ninth Amendment and the Privileges or Immunities Clause, as evidenced by the McDonald decision, in which only one justice was prepared to revive the Privileges or Immunities Clause. And why? It wasn't because they didn't know what the Privileges or Immunities Clause meant. It's because they did know what it meant, and they didn't want to go there. The conservative side of the court wanted to stick to substantive due process, even though they claim not to like it very much, because I think they've got substantive due process in a box where it doesn't work very much. And it doesn't work very much if you follow the Glucksberg line of cases, for example. You'll never recognize another unenumerated right again, and they're pretty happy with that situation. It was clear in oral argument, and I was there for oral argument, that none of the justices, except for Justice Thomas, who doesn't ask questions, was prepared to consider the unenumerated rights that those who wrote the 14th Amendment had in mind, and which are reflected in the original public meaning of the term privileges or immunities. And you have Justice Alito, for example, in rebuttal, asking Ellen Gura whether among the privileges or immunities, does that include the right of contract? Well, this was not a trick question, but it was a loaded question, because A, it's obvious that the Privilege and Immunities Clause did include the right of contract, because the right of contract was specifically mentioned in the Civil Rights Act of 1866, to which the Privileges or Immunities Clause refers, and it was the reason why the 14th Amendment was enacted, was essentially to constitutionalize the Civil Rights Act of 1866, which protects the right of contract. However, we also know, based on the Supreme Court's precedent, that the protection of the right of the liberty of contract is considered a no-go zone. You're not supposed to do that. The Lochner case, which protected the liberty of contract, is part of the anti-canon. It's part of the cases that if your argument leads to that outcome, then your argument must be wrong. And so there's an example of where the right side of the court did not want to go to the Privilege of Immunities Clause, and as Justice Scalia said in oral argument, he's resigned himself to, he's acquiesced to using substantive due process instead. Well, I don't think it's up to the justices to acquiesce. That gets us back to our discussion of precedent. I don't think the justices get to acquiesce to not enforce the Constitution, where it's actually where its meaning is determinable. And the left side of the court has other concerns with protecting liberty across the board. They might want to protect certain liberties, but they don't want to protect other liberties, including, for example, economic liberty. And you'll notice, if you're talking about what's in the Constitution, what's not in the Constitution, there's no distinction in the Constitution between economic liberty and non-economic liberty. In fact, the Constitution speaks of life, liberty, and property by modern rubric is considered to be economic in nature. But that is something the court has hewed to. That is a distinction the court has hewed to, for 50 years, 60 years.